Welcome, everyone, to Loopholes and Lawsuits. My name is Mike Vo, and my colleague is.
Jamie Schrabeck. Before we launch into our discussion, Mike, would you do the honor of reading our disclaimer?
Sure, absolutely. So, for everyone watching and listening to our podcast, the information and advice provided today is not intended to be taken and should not be construed as legal advice. No attorney client relationship is formed through any of the discussions on today's podcast. You must consult with your own private attorney for issues that are specific to your situation. Further, all topics of discussions are based on the law in effect at the time of taping. Please make sure to check for later podcasts of loopholes and lawsuits for any changes in the law.
Thank you for that, Mike. I think that's what we needed to hear before we start today's discussion. Mike and I both approach compliance from our own unique perspectives. And today we're honored to have as our first ever guest for loopholes and lawsuits the person who oversees the agency responsible for the largest population of beauty licensees and beauty businesses in the entire country. And that's Christy Underwood of California's Board of Barbering and Cosmetology. Welcome, Christy.
Yes, Christy, welcome.
Thank you. Happy to be here.
Thank you. Christy, tell our audience a little about your role in state government and the mission of the board.
Absolutely. So, my role is I'm the executive officer of the board. So, I report to a 13-member board. Those board members are mostly appointed by the governor. We have one appointed by the Senate pro tem, by the Speaker of the Assembly. And so we are, of course, the Board of Barbering and Cosmetology, and our main mission is to protect consumers. So that is our focus. Our focus is to make sure people are minimally competent to pass the examination, to get that license, to go out in the industry and work and be safe. We're not here to make sure you do a great haircut or the perfect manicure. We're here to make sure you do it safely for your consumer. So consumer protection is our main goal.
Great. Thank you for that little background about yourself. Jamie, in terms of what we want to discuss with Christy, what were your thoughts on what are we going to talk about today?
Because the board in every state is the agency most aligned with beauty professionals, we could talk about a lot of different subjects, but we wanted to focus today on the topic of establishment licenses. And every state has, to my knowledge, some type of license from the state agency that allows it to operate and offer those services regulated by the board. So, if you could, Christy, if you would explain what an establishment license is and what are the requirements to obtain one?
Sure, I agree. I believe every state in the country has some form of establishment licenses. So we call them establishments. This is your beauty shops, your nail salons, barber shops, facial shops. Lots of people can call them all different types of things, but we only license establishments. So an establishment is a business where any of our services that we regulate are held. And if you're just doing hair, you have to have an establishment license. If you're just doing nails, you have to have an establishment license. So we don't differentiate on what happens in the establishment, but obviously we license hair, skin, and nails. And so anytime you perform those services to a consumer, you have to be performing those services in a licensed establishment. There's a couple little side options that we can do. You can have a personal service permit, but we're going to talk about establishments today. So the establishment license is the business. It's where the consumers go in to receive those services. And an establishment license, to obtain the establishment license, you must apply for that. You have to have a completed application, of course. It's a $50 application fee. You have to show us where your business is. There are several requirements for what needs to be in that establishment. For example, if you're doing hair services, you have to have a closed container, trash can for that hair to be deposited in. You have to have disinfectant solution. So there's many requirements in our health and safety regulations of equipment and products that you would need to have in your establishment. But to gain that license, you apply for a license by just simply filling out our application. You can't, of course, have any prior discipline to gain that license. That license can be issued to a corporation, it can be issued to a partnership, it can be issued to a sole owner. I believe the majority of our licenses are actually sole owners, and it's at one address. And that's the most important thing, I believe. One address for each establishment. And we do have suites that are designated. Everybody knows about the increase of things like the Sola Suites, Phoenix Suites, where it's an actual office building, for lack of a better word, that has been divided into suites. And those suites are little tiny salons, basically. Each of those suites has their own establishment license, but that is because they are a suite. And they are a suite because they've been zoned as a suite by their city or their county. It's different for everyone. And because the United States Postal Office recognizes them as a separate business address. You have to have one address per establishment license unless it's designated to have suites. And you can't, again, focusing that we cannot have more than one establishment license at the same address.
Chris, you raised some really good points about having, recognized suites. I know that come 2025, there are changes with respect to licensee in the manicuring space here in California. Just wanted to run some scenarios. What if I am the only licensed manicurist in a setting, a space, let's call it that, but there's already hair and skin being done, so there's one establishment license. Do I, as a licensed manicurist, need to have my own establishment license to operate in the nail space?
No, you do not. And in fact, we would not issue that. There's already an existing establishment license for that location. And of course, with January 1 coming and the new labor laws that are taking effect, that manicurist would no longer be a independent contractor. They would be considered an employee of that business.
Right. And I know in terms of jurisdiction of your department, you don't handle the labor and employment side of it, but there's a little bit of an overlap as to what our viewers, the licensees, need to be aware of. What if there are multiple licensed manicures in a space and they decide, I don't want to be an employee. I want to stay independent. Can we just put up some drywall in that space and designate space A, B, and C? Would that work?
I believe there's a scenario where you could do that. I am certainly no expert in zoning laws, but I don't believe an establishment can simply put up walls and call those suites and get different establishment licenses. Here's a great example. A lot of establishments that offer skincare services, those skincare services are done in a room. They're not usually done out in the open. And so as of right now, those are all under one establishment license. We don't issue a separate license to a suite within a business. Again, you would have to get zoned. You would have to be able to lease out that suite. It would have to be a lease. And then you're looking at, I would imagine, much more laws than I would even know what to do with. But again, it has to be zoned as a separate business from your city or your county and have a separate mailing address from the United States Post Office.
Got it. Jamie, from your perspective, working in the salons themselves and as a licensed manicurist, what are some of the issues that you've heard through your colleagues with establishment licenses?
Returning to the topic of the application itself, it's my understanding that you have to demonstrate that you have a lease. In other words, you're authorized to work in that space. Is that correct, Christy?
We do ask for a copy of the lease where you are authorized to rent that location.
In terms of contracts, and again, Mike, this is your area of expertise. If you are the person applying for the establishment license and you are attesting to the fact that you are either a sole proprietor or a partnership or an LLC or an S Corp, you are also providing that lease. That's something that you have to have. It's a signed legal document between you and the person who owns the building or who has the right to lease the building to you. So there's all these different layers. And I don't know how much effort Christy and her staff are going to be able to put into evaluating all these establishment license applications that I predict will be coming their way.
Right. I mean, I think that's kind of going to the title of our podcast, Loopholes and Lawsuits. I think there can be a lot of creative ways that licensees and owners are going to come up with as to maybe how to take advantage of a loophole. I don't see this as a loophole or a gap in the law. I think it's very clear that you are required to have a physical address, one establishment per location, unless there are recognized suites. So, in the hypothetical that you've brought up, Jamie, about having subleases, the master lease will dictate whether someone can sublease. So, that's something that the tenant has to consider before trying to create or draft a sublease. In terms of partnerships or a bunch of licensees coming together, hey, we will form a limited liability company. We will form a corporation, whatever entity that may look like.
What I see now are people talking about either getting together with the people they're working with and applying on one application form as if they're in a partnership, or they're thinking that they can sublease from the person who's leasing from the building owners.
If their intent is to come together under one entity to obtain the establishment license, that's fine, so long as they comply with corporate laws, right? They become shareholders in an entity, or they become limited liability members in a limited liability company. With that comes tax obligation. They can't try to evade taxes by saying, well, I am not an owner, quote unquote owner, shareholder, or limited liability member in this company. No, you are, because you guys came together and that's how it worked out. So it would be challenging from my perspective if they were trying to circumvent the establishment license requirements and also comply with the changes here in California come 2025 and be compliant across the board. So from my position, I'm looking at compliance not only with the board's requirements, but what are the corporate law requirements? What are the labor requirements? So there's multiple areas of laws that have to be met. And, I think we're going to have very robust conversations in upcoming episodes of what can or cannot be done with respect to these issues.
Christy, separate from this issue with the licensed manicurists, isn't it the case that you as an applicant, you don't need to have any training whatsoever? You don't have to have your own individual license. You don't have to have attended beauty school. Anyone can apply to become an establishment owner.
That's correct.
That being said, are there circumstances other than maybe this issue with the geography, the location not being zoned properly, or maybe the application is not complete? What other circumstances under which someone would have their application denied?
In talking right now about this sublease idea, what we do when we get an establishment application, the first thing we do is we do what we call a geo search. So we look up the address in our database. And if we see a active establishment license at that address, we then ask, did you purchase this establishment? Because we can't have both. So even in this sublease situation, we wouldn't have any authority over this type of lease situation, but we're not going to issue a separate establishment license. So again, they're going to be in that situation where there's one establishment license is only allowed. And I think it's also important, and it's going to be super important for people to understand that, let's just say they decide to form a legal partnership and they do everything exactly correct as anybody would do. And then they apply for the new establishment license. It's a brand new license because establishment licenses are not transferable. So if I form a partnership with Jamie and I already had an establishment license, I'm now canceling that license and getting a new license. And I think it's important that people understand that once you become a primary holder of an establishment license, you're responsible for the health and safety that goes on in that establishment. We don't currently recognize booth renters or independent contractors. If we go into an establishment and we find something, or if we have a complaint where there's consumer harm and we go in and we find evidence that happened in that establishment, the establishment is held responsible. If we go into an establishment and there's no disinfectant solution, everybody's held responsible. So I think it's important that adding your name to a business structure, as completely as legitimate as you plan to, people need to understand that you're taking on the role and responsibility of actually owning an establishment. And there are requirements that go along with that. Now, you don't have to have that individual license. Anybody can own an establishment. But even those people who never have been in the beauty industry are responsible for the health and safety that takes place within that facility. Correct.
And
When those laws came out and required new posting, they didn't differentiate between a single suite, a single establishment, or a large establishment. So there's no distinction that a salon with only one employee owner doesn't have to have those posted. So the way the law is written, all postings have to be in all establishments.
And then there's the health and safety poster, which is just one sheet of paper. And it's very simple now, directing consumers to contact the board if they have concerns.
Correct. It's a one-page consumer notice. It goes out with the establishment license, whether it's the first establishment license or the renewal establishment license. And then it's always available online if somebody misplaces that. But that has to be posted in the reception area for consumers to see.
And then I believe there's another posting about employment law, which I'm wondering if that's not going to need to be updated given what's happening in January. It's interesting when these laws pass and then the posting requirements go into effect that sometimes the agencies don't circle back to make the corrections that need to be made so that they're applicable to the laws as they are now.
Very true. Yeah, that'll have to definitely be looked at to see if some of the postings that are required by other departments that we look for need updating with some of the new things happening.
Chris, I wanted to ask you, in terms of the application time frame right now, what should a licensee expect from the time they submit an establishment license application to the time it's actually issued?
We are taking about 4 weeks max right now.
And then in terms of that license, once it's, or as part of the issuance, or once it is issued, does the board have any requirements upon the establishment license holder to carry certain type of insurance, whether it's general liability insurance or professional liability insurance, any insurance requirements as part of the issuance of that license?
For us, there's not. So we do not ask for that information.
I think it's quite clear that even if you work alone, you still need an establishment license. It's not just your individual license that makes you compliant. And there are some other requirements, some of them more recent and some of them not nearly as well publicized, that we have to post certain notices in our establishments. Even if you work alone, you have to have posted in your salon a statement about preventing human trafficking.
If I could opine a little bit on the labor postings, in my mind, let's say we have several recognized suites with several establishment license in a particular space. Well, if each owner of that establishment ends up having employees, not necessarily licensed beauty professionals, but let's say someone to help out the front register. And then so that front register clerk is now an employee of that establishment. So under the current labor laws, that would require that that particular suite must have its own posting. So I would not be surprised if I were to walk into a space and there's maybe say 2 or 3 recognized suites, if all 2 or 3 recognized suites had their own separate labor postings because of labor requirements.
I don't expect any one of us is going to traffic ourselves or exploit ourselves. But if the law doesn't specify that it only applies to places where there are multiple people working there or employees, then everyone is responsible for having those same postings. What's the worst that can happen, Christy, if someone operates without an establishment license?
It's $1,000 fine to start. If somebody is operating without an establishment license and they have a personal license, manicurist, cosmetologist license, so they're also looking at not only working in an unlicensed establishment, that could eventually go against their own personal license for discipline. It could be very costly just from our board under our laws.
On that note, home salons, home-based salons, could you briefly just share with our viewers what are the requirements in order to have a home-based salon?
Yes, all the requirements of a regular traditional salon are the same. There's lots of equipment that you need. All of that is the same. Some of the differences are it has to have a separate entrance. You have to have access to a restroom for your clients. But I would say that's for us. Even stricter is your city or your county, because the zoning is often, they don't allow home businesses. Keeping in mind that this industry does tend to use chemicals, and that you're disposing of chemicals in often a residential area. We have found cities and the counties are very strict and getting stricter with their requirements. One, because of the drainage issue, there could be disposing of disinfectant solution down their kitchen sink. And so really the zoning requirements are much stricter than ours. We have a lot of home salons that are very successful, so it can be done. But for anyone interested in that, we highly recommend you talk to your city or county first, because we do know that people have invested to redo garages, move some plumbing to have sinks and restrooms available, and then found out from their city or county that they weren't zoned appropriately. And those can have much more ramifications than even $1,000 fine from the board.
In the short time that we've had with you, just talking about all things establishment, let's say I'm that individual who wants to open that salon, whether I'm a licensee or not. You raised a lot of good questions, a lot of good issues. Is there a resource page with the board that I could go to, or is there someone I can call if I want to talk to somebody?
We highly recommend people email us. We have a general email address, and sometimes we get backed up a little bit because we do get so many emails. And that email address is barbercosmo@dca.ca.gov. And we will answer, especially if you have establishment licensing questions, you can put those in there. Our email response time today is 24 hours. So we're getting responses out really quickly. Again, I really want to stress that we can't answer labor issues. That's the big topic these days, and we are getting a lot of questions, and it's not our law. So we wouldn't want to infringe on another agency's laws or even try to interpret those laws. We can interpret our laws all day, all night, but we wouldn't want to take on the role of interpreting labor laws. It's not within our wheelhouse. We are recommending that when you have those questions, that you do talk to the labor commissioner's office.
Fantastic.
In the future, do you anticipate or would you want any particular changes in the way that the board handles establishment licenses and the application process?
Yes, I think there's many discussions to be had about our establishment application process. Any changes that we want take the board to decide that, and that may take legislation or it could take regulation, which are both lengthy processes. There's a lot of issues out there that we can talk about. Don't issue more than one establishment license to more than one address, but maybe there's an opportunity for us to do that. And I think that's something that we could talk about for sure.
I so appreciate you being here with us, and I hope that we are able to engage with you in the future to discuss other topics.
Sounds great. The one thing I would add from our own email addresses and from things we've seen on Facebook is I really want to get the word out that there is no such thing as a nail salon license. And I think people are not understanding that. They feel that the new law only applies to nail salons. And it doesn't have anything to do with that, since there is no such thing as a nail salon license. There is only establishment licenses. Our board will be discussing AB5 at our next board meeting on November 4th. Again, not our law, but I do think it's important that the board have a discussion and take a policy position on the fact that we would like to see all of our licensees treated the same. And that while it's not within our law, I think it's just really important that people understand that for us, we don't see any loopholes around this. We do see that if you're a manicurist, as of January 1, you are now an employee unless you own your own business. Again, we're not labor experts, but that is, with all the conversations we've had, that is how we are interpreting that today.
Great. Thank you for that comment. I think that's really going to help clarify some of the inaccurate information that's floating out there from the community, those who know, those who don't know, whatever happens to be. I really thank you again. I would welcome you back on our future episodes because there's a lot more we want to discuss.
If you enjoyed this podcast, please subscribe to our channel and share this with your friends and colleagues in the industry. We'll have links for you in the show notes, specifically the ones that Christy mentioned. We would love to answer your questions, so please visit our website at loopholesandlawsuits.com so we can help you in a future episode. Thank you, everyone.
Great.
Thank you.
Thank you, Christy, for your time.